I'm Drew Stevenson, and this is a lecture for my professional responsibility class about lawyer fees and legal ethics, and specifically Model Rule 1.5. That's the part of the model rules that governs fees. And this is the first in a series of videos. It's kind of a big topic, and I broke it up into separate chunks so that the individual videos are not too long. Now, for some of you who have been working a little bit already for firms and are familiar with this, but if you're not familiar with legal fees, you should be aware at the outset that they can be structured in different ways. So you can charge by the hour, in which case you keep track of your time and the client, and there's a certain amount you're paid for every hour. This is actually kind of a 20th century development. It wasn't the way legal fees were handled at common law. You can charge a flat fee for a routine matter. So let's say that you handle routine DWIs, or an adoption, or incorporating a nonprofit or something like that. And you know about how much time it takes. So you always just charge a flat fee of X amount of thousands of dollars for doing that type of work. That is okay. You can charge a contingent fee in certain types of cases, which is a percentage of the, and it could be a percentage of the recovery for a plaintiff in litigation. It could be a percentage of the sale price in transactional work. So keep in mind, you can have contingent fees in transactional work as well. So if, for example, you represent someone who's trying to sell a big piece of commercial real estate or a business, and they want to get as high a price as possible, so they decide to motivate you to be a good negotiator. So they offer to pay you as a portion of whatever the sale price is. We could do a reverse contingent fee where the buyer basically will pay you more if they can get a better deal. And so you can also have retainer fees, which are essentially a period contract. So if you are in-house counsel, this applies to you. You're going to have basically an annual salary for doing all the legal work. Sometimes companies that don't really aren't big enough to have an in-house legal department or in-house counsel will basically keep a law firm on retainer and pay them a certain amount a year, basically to do all of their legal work, regardless of how much time actually accrues. And you can mix and match these, right? If for one representation, you could say there's going to be a flat fee for part of it and a contingent fee for the other part, or part flat fee, and then a contingent fee if we get a certain outcome or avoid a certain outcome, and so forth. So just be aware that fees can take different forms and structures, and some non-lawyers are not aware of this. Okay, let's go through the provisions of Model Rule 1.5. A is a kind of a generic requirement that fees be reasonable. They don't give us a bright line rule for what counts as reasonable. Instead, they give us a lot of factors. So the overarching provision is a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following. First, the time and labor required. That should make sense, right? If something takes a long time and is a lot of work, you're going to get paid more for that. The novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. So if you have highly specialized skills in a specialized area of law, you're probably going to get a premium on your hourly rate or your flat fees. And the same is true if you undertake things that are novel legal claims, because there's a lot of risk involved and uncertainty about the outcome. Number two, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. So you can charge a premium, for example, if representing one client is going to present a lot of conflicts of interest and preclude you from representing other people that you otherwise were probably going to get to represent, let's say, in that field and geographic area. Also, sometimes clients come and want you to drop whatever you're doing and focus on their project, and kind of put other clients' matters off or withdraw from them. And if so, then you can charge a premium for that. That will be considered a factor in whether your fee was reasonable. Also, the fee customarily charged in the locality for similar services In legal jargon, we call this the load star, LODE star amount, and this is the going rate. Obviously, it's going to be higher in major metropolitan areas than if you are in rural South Dakota. But what's the kind of going rate, hourly rate for lawyers in your area? That's going to be our benchmark for comparing whether your fee was reasonable. In other words, you could be subject to discipline for charging too high of a fee. The fourth factor is the amount of money involved and the results obtained. So if this is a multi-billion-dollar case that you're working on, or a multi-billion-dollar merger or acquisition, there's a lot at stake, and so you can charge more. And remember that if something goes wrong, you're looking at a rather daunting amount for malpractice liability, so you can charge more for doing the legal work. Similarly, if you work a miracle and obtain some kind of amazing recovery for the client, we would expect you to be well compensated for that. Time limitations imposed by the client or by the circumstances. So if the client calls you, wakes you up in the middle of the night and says, get out of bed and come bail me out of jail, or come home from your vacation early because I want you to work on something for me. If they have an urgent matter, which means you have to rearrange your schedule for that client, you can charge a above average fee, let's say, for that. That will be one of the factors we consider in whether your fee was reasonable. And the nature and length of the professional relationship with the client. The longer you've worked with a client and they've been willing to pay your fees, the more we think that they've acquiesced to that arrangement and that the fee is reasonable. 7, I told you there's a bunch of factors. The experience, reputation, and ability of the lawyer or lawyers performing the services. If you're the most successful lawyer in town, work at the most prestigious firm, or have obviously years and years of experience, we're paying you for that. Why? Because we think you get things done faster, you know what you're doing, you're not going to make mistakes, and so forth, and whether the fee is fixed or contingent. Now, B is where we get into the stuff that I think you're more likely to see on a test. We're going to start getting into some bright line rules. So first, the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing. So remember, it doesn't have to be in writing. Watch out for gotcha questions that ask you if all fee agreements have to be in writing. They don't, but it's better. It's best practices if they are. But somehow you have to explain to the client how much they're going to pay and if they're going to be responsible or get stuck with kind of expenses and costs and reimbursements on top of your whatever your legal fee is, the fee for your lawyerly work. And preferably in writing before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis. So if you've been representing a client for a long time, they call you and say, hey, I have a new matter for you. And you can just say, okay, it's my usual fee, and that's enough. But what we don't want is surprise after the fact for the lawyer to say, oh, I'll be completely reasonable or give you a discount. And then the client is completely shocked by the bill later on. Also, if you're going to try to change the basis or rate of the fee or expenses, you're going to have to communicate that to the client. So don't just surprise the client at the end of the representation with a big bill and say, look, I know I agreed to do this on a contingent fee basis, but once I realized we're going to lose no matter what, I switched to keeping track of my hours, and now you're going to pay me for the actual work I did because you wanted to keep going after I told you we were going to lose. The client has to agree to changes ahead of time. Okay, C is about contingent fees. A fee may be contingent on the outcome of the matter for which the service is rendered, and this could be true in litigation or transactional work, except in a matter in which a contingent fee is prohibited by paragraph D or other law. And contingent fees, here's a bright line rule that I guarantee you're going to have a question about on the MPRE. A contingent fee agreement has to be in writing and it has to be signed by the client. Now, remember, for some of our other rules, we say that you have to have disclosures in writing or the client has to agree in writing. This is a writing signed by the client. and it states the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal. Because remember, what happens if you win and then the case gets reversed on appeal? Do you have to give your feedback? Spell it all out in the engagement letter. Litigation and other expenses to be deducted from the recovery, and whether or such expenses are deducted before or after the contingent fee is calculated. So the hypothetical here is, I'll pick a round number. You told the client that you were going to charge 40% contingent fee, and then you get $100,000 recovery at the end of the case. The case settles, or you get a verdict for $100,000. And so you had $20,000 in expenses, right? You hired experts, and there were court filing fees and photocopies and stuff like that. When you added up all the costs and extra expenses, it's $20,000. And so you send the client, you take your $40,000, and then you take $20,000 and pay the expenses, and you send the client the amount that's remaining, which is 40, and they're going to call you and say, you sent the wrong check. This is your amount. I'm supposed to get 60. And if they say, oh, no, all those expenses were supposed to come out of the lawyer's share, well, now you have a misunderstanding. You should have put that in writing ahead of time. And the fact that you didn't means that you could be subject to discipline, but it's also your own fault that you didn't clarify this for the client, because it was so predictable that there would be misunderstandings about whether you're going to take out your percentage before or after the expenses are paid. You have to clearly notify the client of any expenses for which the client will be liable, whether or not the client is a prevailing party. So if you're in a loser pays jurisdiction where the client could be responsible for the other side's attorney's fees, you better spell that out in your contingent fee agreement, because a lot of clients think, oh, if I don't win, I don't have to pay my lawyer anything, but they could actually have to pay the other side's lawyer, and they need to understand that. It keeps going with contingent fees. Remember, there has to be a writing signed by the client at the beginning, and then at the end of the matter, there's another written document, basically that you provide to the client, stating the outcome of the matter, and if there's a recovery, showing the remittance to the client and the method of its determination. So just for purposes of gotcha test questions, remember, there's 2 written documents required for contingent fees, at the beginning and at the end. D. These are the 2 situations in which you must not charge a contingent fee. You cannot enter into an arrangement for, charge, or collect a contingent fee in any fee in a domestic relations matter, that we mean like divorce or separation, legal separation, the payment or amount of which is contingent upon securing a divorce, or upon the amount of alimony or support or property settlement in lieu thereof, or a contingent fee for representing a defendant in a criminal case. Why in the divorce case? So in a divorce case, you're going to be charging basically an hourly rate or a flat rate, but no contingent fees. We don't want to give lawyers a perverse incentive to sensationalize or aggravate the amount of spite and bad feeling and recriminations and accusations between the soon-to-be divorced couple. And we're worried that the lawyers will escalate the situation in hopes of getting a higher amount of alimony, and that's contrary to public policy, or a higher contingent fee on the alimony or child support. No contingent fees in criminal cases. Why? Well, a lot of times, remember, 95% or so of the criminal cases end in plea bargains. They don't actually go to trial. And a plea bargain almost always involves your client admitting guilt and accepting some sort of punishment or consequences in exchange for admitting guilt, but hopefully a lighter sentence, right, than they might face if they were, or lighter charges if they went to trial. We don't want to create a perverse incentive for lawyers to advise their clients against taking a generous plea offer from the prosecution because the lawyer is afraid that they won't get as high of a fee as if they go to trial and secure an acquittal for the defendant. So you simply can't charge a contingent fee for representing a defendant in a criminal case. And if you even try to, right, make the arrangement, and let's say after it's all over, you never get paid, that's no defense, because notice that the rule says you can't make the arrangement or agreement for. Even if you end up never getting paid the contingent fee in one of these types of cases, you could be subject to discipline for agreeing to do it on a contingent basis in the first place. A division, this is we're getting near the end, I promise. A division of a fee between lawyers who are not in the same firm can occur, may be made only if, so think about this, some cases, client matters, we're going to bring in multiple firms to work on it, maybe because it's very complex, or it spans, there's parts of the case occurring in different states or something like that. But it could also be because different firms are handling different phases, like one firm does the trial and another firm does the appeal and so forth. First, the division has to be in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. So there are some lawyers out there, almost every state has some lawyer who runs commercials claiming to be the hammer for that state, and they invest heavily in television and radio advertising in order to sign up clients. And then, for example, the Texas hammer historically would refer out most of most or all of those clients and not actually do the cases. So the business model was to spend heavily on advertising, sign up clients, and then refer them to other firms to do the legal work and get a referral fee. And so this is sort of the rule that put a stop to that, because you can't get paid. If you did no work on the case, then you should get no payment unless you're basically being paid for assuming the liability if something goes wrong and there's a malpractice action. That's E1. E2, the client has to agree to the arrangement. We had some concerns in the past that a lawyer would sign up a client and then call their friends from law school who work at other firms and sort of pile on all these lawyers from different firms, and the client would start getting bills from firms they never heard of for work that they did on the case, and it's not the lawyer they thought they had hired. So the client obviously has to agree to every lawyer that's going to get paid, including their share that they're going to receive. And the agreement has to be confirmed in writing. And the total fee still has to be reasonable, not just each individual lawyer's fee, but the total fee. Now, that concludes our initial lecture about the core provisions of Rule 1.5, but this is a to be continued because I have another a video after this that's going to go through some of the specifics, details in the comments that I think you could see as test questions, and then some examples from court cases and ABA ethics opinions that also functionally are rules about fees that you should be aware of.